Shilpa, that's a very good reply. So it's an investigation of some sort of the past, basically. Exactly. Whether the compliance requirements are being met or not, the title and rights. Yes, particularly when it comes to real estate, why due diligence is a very important procedure is generally in a sale. Basically, you need something called a title clearance document or a title deed, right? Okay. So basically, to check whether, like, obviously, like if I want to sell something to you, I should have undisputed, unencumbered ownership to this thing. Only then I have the right to transfer that the same, right? So due diligence is basically an investigation of some sort, you can say, or basically you just check out whether whatever I want to transfer, be it the ownership or the interest in any property, is it basically free from all existing encumbrances, charges, and there is no existing disputes regarding this property. Tomorrow, if you come to know that some property is basically being dealt with, so at the end of the day, you will not obviously want to buy any disputed property or even rent or lease for that matter, any disputed property. So this due diligence procedure is actually undertaken to make sure that the title of the property is absolutely clear and undisputed. At the same time, there are other considerations, especially when it comes to your lease or commercial lease agreements. When you do the due diligence, you also come to understand whether the compliance requirements are there, all the licenses, permits, check, balances, everything is in place or not. When it comes to real estate due diligence, the concept of due diligence, not the procedure. I'm not going to deal with the procedural aspect of due diligence because it's a very elongated process. The concept of due diligence becomes very, very imperative to understand. All right. So without due diligence tomorrow, if you undertake the lease or sale of any property, any kind of transaction with any property, you may end up in trouble. Secondly, to figure out one of the most important clauses, that is your condition precedent clauses, the procedure of due diligence also becomes imperative. For example, there are certain industries. I want to lease a commercial space to run like a restaurant of some sort, a theater of some sort, all right? Liquor industry, okay? I want to run a bar or something. There are certain licenses, permits, checks that is required to be met. Before the transaction happens, you need to undertake a proper procedure to investigate whether this checks, this permits, this licenses, everything is in place or not. If you find that there are, suppose for example, the property you're going to take up on lease has certain unpaid rent, taxes or some sort, you can just immediately carve that point out and put it in your condition precedent clause immediately before you execute the agreement. Okay? So this is the reason why, especially when we talk about real estate contracts or real property transaction of some sort, the concept of due diligence becomes very important. At least from the knowledge perspective, we really need to know about this concept. Another important point is the difference between your lease and license. Correct? It's only permission of some sort. I am allowing you permission to basically for certain kind of action to do here in my property. Whereas in lease, there is a very clear transfer of interest. This is exactly your basic difference. So next week only we have your leave and license agreement. That is the reason why I chose to pick up this topic when we are discussing commercial lease agreement itself. So here in a lease, there is a very, very clear transfer of an interest that takes place. Whereas license, you just give a bare permission without any transfer of any sort of interest here. So lease creates, obviously, since there's a transfer of interest, it creates basically an interest in favor of the lessee. But in a license, no such interest, because no transfer of interest is at all taking place here, right? So there's no such transfer of interest that is happening. So obviously there's no interest in favor of the lessee is created. Lease is both transferable and heritable. Subtenancy can be created out of a lease basically, but in license, again, the corollary can be drawn from the very fact that there's no interest transfer. Basically, it is not transferable or heritable in any way. So there are like kind of 8 points of differences that I have enlisted out here. Go through this for your bare understanding. This is a very important concept. Okay? So there are certain interrelated concepts, when we basically study, like for example, we had already For some of you, we had covered corporate contracts, and for those of you, it is left, we are going to cover it in the upcoming sessions. So when we are talking about your share purchase agreement, share subscription agreement, and shareholders agreement, these are all interrelated documents. So whenever we are basically going through such interrelated documents, it is very important. For example, in commercial contracts, there's the concept of franchisee agreement, distribution agreement, right? So there are a lot of similarities in such type of agreements, whereas there's fine line differences also in such type of agreements. So whenever we are dealing with such interrelated topics, I feel it's a very good practice to carve out the points of differences, the points of similarities between the, conceptually at least, between the types of agreements, and basically do a holistic study of this, like basically go about it very holistically rather than just picking up independent topics. So tomorrow, if there's any conceptual clarity your client requires, you will be very good to basically input that. So that's the entire point. So anyway, next week we have the lease and license agreement, as I told you. So lease and license, just remember in one word, the basic point of difference is in lease, we transfer some sort of an interest, whereas in license, we just give a certain permission and there's no transfer of interest as such. This is the basic difference. That's it. Chandni, I just repeated the entire thing. License deed comes under, yes, Hardeep, yes, it does. It does. Chandni, I have just repeated it. In lease, there's a transfer of interest. In license, there's no such transfer of interest. That's the basic point of difference out here. Shilpi, consideration forms a part of both the agreement. Consideration has got nothing to do with. Consideration is a part of both. For the permission also, you are transferring certain consideration, and for taking it on lease also, you are transferring some sort of consideration. Consideration has got nothing to do with this. Now coming to the most important clauses out here. Okay? So as usual, I have listed out the important clauses, what the contents of the clauses are, what do you negotiate in those clauses in this document. First and foremost point is your security deposit. Now this is also a very bad litigation point. What basically is one of the most important aspects. Generally, when it comes to commercial lease agreements, security deposit becomes a point of contention also for the reason because in commercial lease, the amount of security deposit is generally higher than lot higher actually than your residential lease agreements or residential lease arrangements. Therefore, this clause is actually a very negotiated clause. It's one of the most major clauses and also one of the most disputed clauses. Negotiating the security deposit, demarcating it clearly when you're drafting the agreement basically, and what can be deducted from the security deposit and under what circumstances such deductions can take place, whether any inspection is going to happen, if it does, what kind of inspection is going to happen. For example, generally the damages and all that is paid. Security deposit is actually taken for these two purposes only. One is when you damage the property, to basically deduct money and make good of those damages. And secondly, if you're like continuously missing on payment of rent, then there are certain ways it is adjusted from your security deposit. So basically, that is the reason why your security deposit becomes one of the most important clauses to negotiate as well as capture in your agreement. Okay? Lock-in structure. Lock-in period, I think we all know here what is the lock-in period. Is anyone not aware of the lock-in period? Basically, lock-in period is like a freezing period. Like, I don't know how many of you have deposited in, like, invested in mutual funds or anything, but you will see that there's this lock-in period in such investments also, like where you can't do anything. You can't withdraw the money. You can't basically take any action against the money that you have already invested or deposited. So basically, lock-in period is a period of time where your rights are kind of suspended. It's frozen. You cannot terminate the agreement. You can't take any action against it. Okay? So lock-in period is a very important, like, since when it comes to commercial consideration, like commercial lease agreement is absolutely entered from commercial perspective. So it becomes very imperative to understand the lock-in period to basically capture it. Again, it's a negotiated, highly negotiated clause. For how much time? Generally, lock-in periods are not more than like 3 months or something. But again, it depends on the negotiation. So therefore, carving out the lock-in period, specifying the suspended rights under the lock-in period, during the lock-in period, and negotiating obviously the lock-in period, it becomes very imperative when it comes to your commercial lease agreements. Post major, this is generally treated always like, used to be treated like a, as I have said time and again, that post major clause has like suddenly gained very vital importance during and after your COVID. So previously, force major clauses, like basically everybody would just copy paste this. This is one of the most neglected clauses. Suddenly this clause gained like momentum when such a pandemic happened. Everything closed down. People didn't have work. People didn't have money to do anything. So therefore, force major, because again, from commercial perspective, if you think something of this sort happens, where your income, your means mode of money generation, everything is closed down, from a commercial perspective, it has a huge impact. Therefore, capturing the force major events, understanding that how do you deal with such force major events, what are the consequences of these force major events on your agreement. Okay? This becomes very important because we have already seen the consequences of a very vital force major event. Like we are probably already facing such consequences all over again. Okay? So, I mean, as usual, it becomes a very important point of consideration here. Exactly. Like suddenly after pandemic, like sanitizer became like such an important thing. Like I didn't even know it existed, so unfortunate. I didn't even know before COVID that there's something called a sanitizer also has usage and stuff. My God, seriously, COVID was like such a eye-opener. I'll never forget this COVID period, never in my entire life. Anyway, use of common areas and maintenance charges. Acha, there are 3 things that I have enlisted in this CAM or common. We have a separate common area maintenance agreement class also for you. But anyway, there are 3 things that I have included here. One is equipment and facilities. Second is your parking space. Lastly is your signage area. Okay? Now, signage area ke liye generally there are actually separate clauses carved out. It is actually not used under common area maintenance clause. Okay? So, but at the same time, you can also have separate clauses for equipment and facilities, parking space, and common area and maintenance charges. Although these are actually equipment, facilities, parking space, this do fall under the definition of your common area itself. But then sometimes you can use different clauses also to capture it separately if the need be. Okay? So common area, what is the common area? Suppose there's a lift in an apartment. Okay? There's a lobby in an apartment. There's a garden space. Right now, apartments have like gyms and swimming pools. So all these facilities are everything. Everything is there in your apartment only. Okay? So basically, all of these things that can be used and will be used basically potentially by everybody. Either they're taking it on lease or they're residing in such spaces, whatever it is, they are going to all basically use it. So obviously, like tomorrow, the lift that is being used by everybody, okay, I mean, the logical part is that if there's any problem in the lift, then everybody will be paying for the maintenance, for the repairing charges, repairing costs. So this common area is actually, I think all of us are aware with this concept of maintenance and all that we pay every month, and we are like living in apartments and all that, right? So for this common area, you carve out a separate clause. The mechanism in which this common area maintenance charges will be paid. Sometimes it's taken annually, sometimes it's taken monthly. So whatever be the schedule of payment in this, all of these needs to be very specifically carved out, negotiated and captured in the agreement itself. Okay? Somebody, I don't know which session, asked a very weird question to me, that if a person is like staying in the first floor of an apartment, should that person be paying like common area maintenance for lifts and all? Thankfully, none of you have asked me this question here. But yeah, like it is not done that way. Like main nahi use karti, so like I'm not going to pay, not like that. Everybody, anything that is included in the common area of a property, everybody has to pay the maintenance charges for the same. Okay? That's the rule. Signage area is when you go like walk through malls and all, you see like the boards, right? Like of the display boards basically, where you are you can check the name of the store and then enter and all, right? The signage area is basically which shop or which establishment is going to have how much particular area for the display of these boards and all that. Okay? So signage area is generally there's a measurement, very specific measurement, and that measurement itself is covered in your commercial lease agreement, where you provide the measurement, and according to that measurement only you can basically display the boards or the anything that you want. Okay? So signage area, again, this is also a very important clause. Little neglected clause, but then I think it's actually can be rendering to dispute. So I think it's better to just include this, negotiate this, and include this, because this area is a very prefixed area. There's no negotiation done after, like already this has been captured and everything. So this is a prefixed area, and it's better to basically capture this in your agreement itself.